If you've been following the Charlie Adelson appeal to the First District Appeals Court in Florida, well, they finally made a decision. And Adelson raised 5 main arguments on appeal. The court affirmed his claims regarding text messages, hearsay evidence, and cumulative error without further comment. So if you're wondering why the appeal court affirmed the trial court's decision on the text messages and phone calls, let's look at what that was all about, and then you might understand why the appeal court affirmed that decision. And then we'll look at what the appeal court did focus on. Regarding the text messages that were not allowed in, so there was a 50-page exhibit containing more than 400 text messages. According to Adelson, these messages showed that he communicated normally with the co-conspirators Katherine Magbanua, Donna Adelson, and Wendi Adelson immediately before Markel's murder. And they argue that the 400-plus messages Adelson proffered were sent between June 2nd, 2014 to June 7th, 2014. It was during this time that Sigfredo Garcia, along with his friend Luis Rivera, made their first unsuccessful attempt to murder Dan Markel. According to Adelson's attorney, Adelson's text messages were relevant because they showed his state of mind, and that Adelson was focused on everyday activities during this first week of June 2014. Adelson's lawyer also thought that Adelson's text messages could explain away the heavy phone call traffic between Adelson and his co-conspirators during that first week of June 2014. The trial court did not believe that all the calls in Adelson's composite were relevant. The trial court also cautioned Adelson's lawyer that the text messages he sought to introduce contained racist remarks and sexual explicit content. The record supports the trial court's concern. Adelson offered to redact this offensive material, but persisted in his attempts to enter all 50 of the texts into record. The trial court declined this proposal. Instead, the court ruled that Adelson could introduce individual text messages if they were relevant and did not contain hearsay. Adelson never tried to enter any individual relevant text messages into evidence. Instead, Adelson testified that he had reviewed all the text messages he had sent and received from the 2nd of June to the 7th of June 2014. Adelson also confirmed that none of these texts mentioned murder. Also, Adelson never proffered any text messages from July 2014, the month when Markel was killed. So what I just read from is from the appellant's answer brief, and you can see it up on the screen. So, the appeals court is saying that the trial court got it right when they said Adelson could offer individual messages in, and obviously the trial defense attorney didn't do that. So was it error not to allow all of the 400 in to show that, there was regular contact? I think that's what the appeal attorney was trying to say, that this was another error not to allow them all in. And obviously the appeal court didn't agree with that. So this is what the appeal court focused on. It focused on its written opinion on his first 2 claims. So what that means is those text messages, hearsay evidence, and cumulative error were upheld, and the appeals court agreed with the lower court, and as a result, the original ruling will stand. So let's look at the other 2 claims. The one was a motion for change of venue, and Adelson argued that the preservation pretrial media coverage made it impossible to secure a fair and impartial jury in Leon County. The appellate court ruled that Adelson failed to preserve this issue for review because his counsel did not submit the motion in writing with supporting affidavits as required by the Florida court's procedure, and failed to renew the motion before the jury was sworn in. So the appeal court decided there was no fundamental error. The court found that the trial court meticulously vetted the 130 prospective jurors individually. Any jurors who had formed an opinion on Adelson's guilt were excused. The 12 seated jurors demonstrated to the court that they could remain fair, impartial, and decide the case strictly on the evidence. Furthermore, Adelson did not provide concrete evidence that the media coverage was inherently inflammatory. To that response of that the community was saturated with the media reports, the appeal court mentioned that most of the prospective jurors learned about Markel's murder through news outlets like ABC, CNN, Fox, the Tallahassee Democrat newspaper, and WCTV, a local television station affiliated with CBS. Nothing in the record suggests that these news sources were anything other than factual, or that the reports included anything inflammatory about Adelson. Adelson argued that the entire pool of prospective jurors was tainted due to the inappropriate comments regarding the case made by some individuals in the jury assembly room. Adelson argued that the entire pool of prospective jurors was tainted due to the inappropriate comments. The court felt that the preservation, they didn't make a preservation of this, similar to the venue issue. This claim was not properly preserved because the motion was made orally rather than in writing, violating, Florida court criminal procedures, and was not renewed before the jury was officially sworn. So the appeal court felt that there was no fundamental error, that the casual factual comments overheard, such as referencing an FSU professor or a divorce, did not share facts outside what would be presented at the trial. Additionally, expressions of opinion on guilt by a few prospective jurors are generally insufficient to taint an entire panel. The trial court removed all individuals who admitted to discussing the case and even offered to let the defense review surveillance recordings of the assembly room. And if you remember, if you watched the trial, Adelson's counsel declined to review those recordings. So in conclusion, because Adelson failed to legally preserve his procedural challenges and could not establish that any fundamental errors occurred during jury selection, the First District Court of Appeal upheld his conviction and life sentence. For those of you who don't remember, Charlie Adelson was found guilty by a jury of first-degree M, conspiracy to commit M, and solicitation to commit M, receiving a sentence of life in prison plus 2 consecutive 30-year terms. So for those of you who may not know, I've got an extensive playlist on the shooting of Dan Markel, and I find that this appeal decision is very easy to read. They even go through all of the comments the panel jury had said, and they made a point that because the judge has discretion and he was in the room to hear them, and he was in the best position to know if they were being honest. The other thing I noticed is that the trial attorneys did not preserve the appeal issues, so that's really important. And the other thing was trying to say that there should have been a new venue, a different venue. They didn't have any evidence of what was in the media that could have been prejudicial. So I think this case is finished, but you never know, they might appeal the appeal. I guess we'll have to wait and see. What do you think of that? did the Court of Appeal make the right decision? Sounds like they did. Let me know your thoughts in the comments section.